Welcome again to this episode of You and the Law. It's brought to you courtesy of Monday Justice, and it's our effort to sensitize, inform, and educate people of their rights, of their relationship with the law, of how they stand with the law in every aspect of their lives. Last week, the episode last week, we received reactions from people, and we also found out that many people were unable to watch. They found they had difficulties in watching the last week episode, and we encourage you to subscribe to this channel and then turn on the notification so that whenever we have any episode, you'll be notified and you can watch it directly from the channel, so you won't have any difficulties connecting to all our broadcasts. Last week we talked about generally the fundamental human rights. We discussed the foundations, what they really mean. We distinguished fundamental human rights from human rights, and our conclusion was that fundamental human rights are those human rights that we can enforce because they have been recognized by our own local Nigerian laws. Because of that recognition, we can now enforce them in Nigerian courts. Now, we also concluded that these rights have morphed. People in other climes have moved from the first generation to the second generation and to the third generation rights, and Nigeria is still grappling with the first generation rights. And we encouraged everyone that this is an avenue for you to know these things and insist on them. If you don't insist on them, nobody will serve you these things on the platter. Now today we're going to talk about the right to life. The right to life. The right to life is provided for in section 33 of the 1999 Constitution. It provides clearly that every person is entitled to a right to life. Every person has a right to life, and no one shall be intentionally deprived of this right save in the execution of the sentence of a court in respect of a criminal offense which somebody has been found guilty of in Nigeria. Now, this right, it is very clear. Every person has a right to life, and no one shall be intentionally deprived of these rights. Now, first of all, we're going to talk about the arbitrary deprivation of life in Nigeria before we come back to the right to life itself. Because as we have seen, this right is divided into two. There's an and, a conjunction. Every person has a right to life, and no one shall be deprived of this right save in the execution of a sentence of a court. The only exceptions to the right to life, that's when somebody can be deprived of his right to life, as we have seen under that section 33(1), is when the person has been convicted of a criminal offense in Nigeria. That's when the person has been convicted by a competent court of a capital offense. Capital offenses are those offenses that the law prescribes the capital punishment, which is death. The death sentence is an exception to the right to life. If you're convicted by a competent court, note, competent court and conviction. Once you're convicted, your right to life can be deprived you. In most other countries of the world, the death sentence has been abrogated. They have removed it from their laws because they feel it is against the right to life. But in Nigeria, our courts have been consistent in holding that the death sentence is not an affront, is not an infringement on the right to life. As far back as 1990 in Kalu and States, the Supreme Court held that the death sentence does not offend the right to life. Even as recent as 2011 in Amoshima and State, the Supreme Court also upheld itself, holding that the death sentence is also not an infringement to right to life. Under section 33 sub 2, the law also makes some other exceptions to the right to life. For instance, the law provides that where reasonable force is used for the purpose of apprehending a criminal, arresting a criminal, or for the purpose of preventing an arrested criminal, an arrested suspect from escaping, an exception to the right to life. Now, this is to make room for the police to exercise the powers they have under Section 214 of the Constitution and Section 4 of the Police Act. The police have been entrusted with preventing crime, protecting the lives of people and upholding law and order. And for them to prevent, to investigate crimes, the Constitution has to make room for them so that they can use reasonable force. And if in using reasonable force, death occurs in these circumstances, it does not offend, it's not an infringement on the right to life. Now again, where reasonable force is used to protect yourself from violence or to protect your property, such force, if it results in death, will not also be an infringement on the right to life. Now again, where the government uses reasonable force in order to quell a riot or an insurrection or a mutiny, is also an exception to the right to life. Now, in talking about the right to life, in talking about arbitrary deprivation of life, where does the right to life start? Will a person wait till he is killed before he is deprived of his right? This has engaged our courts, and the courts have concluded that a person does not need to die before his right to life is infringed. Now, in a number of cases, beginning from Chief Uzogu and Ezeonu, the Supreme Court have been consistent. It was the Court of Appeal. They held that Nikki Toby JCA, as he was then, he held that a person must not lose his life. And in fact, if a person loses his life, he cannot agitate. Nobody can agitate on his behalf because the fundamental rights are personal. So once you die, you cannot come under the right to life as in Section 33(1). What Section 33(1), the right it protects is for people who fears, where somebody has shown that has evinced an intention, has evinced an object that he wants to kill you. At that point, the right to life as in Section 33(1) has already coalesced and you can go to court. This is the provision of Section 46 sub 1 of the Constitution, which says that if this right has been infringed, is being infringed, that it has been infringed in the past, is being infringed, or is likely to be infringed. Now, Nikki Toby JCA, construing this section, now said that once there's any overt act, any overt action by a person who intends to probably kill you, at that point, your right to life has been offended. Now you can approach the court. So you don't need to wait till you die. You don't need to wait till somebody kills you. Once you fear that somebody has an intention and he has demonstrated that through overt acts, for instance, bringing out a weapon or writing something or doing anything that shows cogently and tangibly that he has an intention to kill you, the law is that you can at that point approach the court. The same decision was upheld in Maduka and Ezeaduka. In Maduka and Ezeaduka, the court also held that once there's an overt display of this intention, of this internal intention to infringe your right to life, you can approach the court. Now, this right to life, there are some issues which usually crop up when we're talking about the right to life. First is, does an unborn child, can his rights be infringed? His right to life being infringed? That's a question. It's a conundrum, actually. And there are schools of thought on this. For instance, there are the pro-lifers, there are the pro-choice advocates. Now, people in the pro-life, the pro-life school of thought, they think that they believe that life begins at conception. That once there's fertilization, life begins. And it is not in anybody's place to now begin to divide the development of the fetus in the womb, to know when he becomes viable, when he can live outside the mother's womb, or when he becomes a child, when he becomes a person for the purpose of the law. That once there is conception, at that time, at that moment of conception, life begins. Now, for the pro-choice advocates, they think that because of the right to privacy, the pro-choice advocates, their advocacy was heightened by the decision of the court in Roe and Wade. It's a United States decision. It was decided in the United States, where the court now upgraded, saw the privacy of the woman to cover the child in her womb, such that a woman has the right over the child in her womb, and she can determine whether to eliminate it or to let it stay. And that's the essence, that's the gist of the pro-choice advocates, that a woman has everything in her body and the child in her womb is part of her body, and she can decide to eliminate it or to keep it. Now, Nigeria does not give us, the law in Nigeria does not give us the luxury of these debates, because as far back as 1932, in R and Edgar, the state and Edgar, the court held that abortion is criminal in Nigeria, except for situations where the life of the mother, the life of the prospective mother is at risk. That's the only time abortion can be prescribed and can be allowed under the Nigerian law. That's it for abortion. Now we talk about the issue of suicide. Now, the right to life, can one on his own determine that he doesn't want the right to life, that he wants to do away with his own life? Again, we'll dispense with many of the philosophical arguments in this area and just tell you that the Nigerian law criminalizes suicide. Section 280 and 281 of the Criminal Code of Enugu State criminalizes suicide. In fact, it doesn't just criminalize suicide, it criminalizes inducing, procuring, counseling suicide. In fact, the punishment for counseling or procuring suicide is life imprisonment, when the punishment for suicide himself, that's the attempt to commit suicide, is a misdemeanor and is punishable by 1 year imprisonment under section 281 of the Criminal Code of Enugu State. Away from the deprivation of the right to life, let's talk about the right to life itself. Does the right to life, does it extend to the right to a livelihood? Does it confer on a person the right to probably social security, to a guaranteed minimum income? That's the big question for today, and our discussion will mostly border on this area, having dispensed with the idea of unlawfully depriving somebody of his right. We have found that the only occasions where these things can be excused is in the case of the death sentence, execution of a criminal who has been found guilty of a capital offense. And capital offenses are armed robbery, murder, treason. These are the three major capital offenses. These offenses, the way they are defined, is that comes with the punishment of the death penalty. So once anybody is found guilty of any of these three offenses, the law does not even give the court, doesn't give the judge any discretion in sentencing. The punishment is stated very clearly, is life. That's a death sentence. And usually the law also specifies the mode of death. Usually the criminal code specifies that death will be by hanging, while the Armed Robbery and Firearms Act, that one the Armed Robbery and Firearms Act prescribe death by shooting squad. So this is one of the ways that a person's life can be deprived. We also talked about use of reasonable force in the course of police carrying out their duties. We don't have many Nigerian cases on this area, but in the United States, there's a Connor and Graham, where the court set out three major things that will determine whether force was reasonable in each circumstance. For instance, the court considers the severity of the offense alleged. It considers whether the life of the police officer in the instant case was endangered. In Tennessee and Graham also, the court also considered whether the use of force was the only option open to the law enforcement officer at the point in time that he used it. There are no local cases on these points, but these cases from the United States can help guide our courts and guide everybody in knowing when reasonable force, factors to consider in knowing when force is reasonable or unreasonable. Now, when we're talking about the right to livelihood. Now, several, like the Universal Declaration of Human Rights, we talked about it last week, which makes provisions. It was signed. It was promulgated on the 10th of December 1948. Now, Article 2 provides very clearly that everybody has a right to life. Again, the International Covenant on Economic, Social and Cultural Rights, it also makes very, very clear provisions that the right to life is inherent in every human being, and state parties must take actions to protect the right to life. Now, under Article 22, 23 and 25 of the Universal Declaration of Human Rights, that instrument makes it very clear that every person is entitled to social security. Every person is entitled to work, a right to work. And every person is also entitled to a standard of living that will help him have a healthy life with general well-being. These are sections, articles in the United Declaration of Human Rights. Now, Nigeria became a signatory to this declaration upon independence. Nigeria also signed in 1993 the International Covenant on Economic, Social and Cultural Rights, the same way with the International Covenant on Civil and Political Rights. All these instruments make elaborate provisions on the right to livelihood of every person. Now, Nigeria has been very slow. Of course, everybody knows, we all can see that the world over, the poverty level in Nigeria is way above average. Nigeria is not the poorest country in the world, but the individual citizens in Nigeria suffer abject poverty more than comparable countries outside Nigeria. Now, can we say, and that's the argument, and that's the major point of today's broadcast, can we say that Section 33(1), which provides in the first segment that every person has a right to life, can be interpreted to include a right to livelihood? There's only one Nigerian case where this question came up, and it was in the case of Daniel Chukwunonso Ogbe and Attorney General of Enugu State. In that case, the Judicial Staff Union of Nigeria had gone on strike, on a strike action. They had embarked on strike on the 11th day of July 2014 because of the failure of the Enugu State government to abide by an earlier decision of the Federal High Court, which granted financial autonomy to the judiciary. Now, because of the failure of the Enugu State government to abide by that judgment, Judiciary Staff Union of Nigeria now went on strike, occasioning a nationwide strike, which led to the close down of all the courts in Nigeria. Now, Chukwunonso Daniel Ogbe was a legal practitioner. He now filed an application for the enforcement of his fundamental right to life in the Enugu State High Court, claiming against the Enugu State government that their failure to abide by the judgment of the Federal High Court has occasioned a deprivation of his source of livelihood. The matter came before Honorable Justice Onora, and Onora held. He, first of all, bemoaned the absence of Nigerian authorities on the right to life, the right to livelihood in Nigeria. But he now made reference, he made recourse to the Indian practice. Now in India, Article 21 of the Indian Constitution of 1950 makes it very clear that every person is entitled, in fact the section is couched negatively, that no one, it does not contain the first aspect as the right, everybody has a right to life. It only contains that nobody should be arbitrarily deprived of his right to life. And the Indian Supreme Court, in a number of cases, in this Ogbe and Attorney General of Enugu State, Honorable Justice Onora examined two of those cases. He examined the decision of the court in Olga, Tellis and Bombay Municipal Corporation. In that case, the Chief Justice of India in 1986, when the decision was made, who was Chandrachua, C.Y. Chandrachua, who was the Chief Justice, Chandrachua decided that depriving someone of his source of livelihood amounted to depriving a person of his right to life. And in making that decision, he was only following an earlier decision of the same court in 1980, in the case of Francis Kalori Mullin and the administrator of Union Territory of Delhi. Now, Honorable Justice Onora, reasoning with these decisions, now held that the right to life in section 33 of the 1999 Constitution also extends to the right to livelihood. This is the only decision on this matter, as far as we know now. So, but it's a step in the right direction. Now, in that case also, Onora made it very clear. He cited the case of Inakoju and Adeleke. Inakoju and Adeleke, a Supreme Court case where the Supreme Court also held that where the court does not find local decisions on similar provisions that's where there are similar provisions in our constitution and another country's constitution, and our courts have no decisions on our own provisions, but there are decisions on the foreign decision, the court, in interpreting our own decision, can adopt the decisions, the reasoning in the decisions, in a similarly couched provision in a foreign constitution. Now, even away from the judicial pronouncements, paragraph 3A of the Fundamental Rights Enforcement Procedure Rules 2009 makes it very clear that the fundamental rights in chapter 4 of the Constitution must always be interpreted expansively and purposively in order to advance the rights contained therein. Paragraph 3 sub B of the same Fundamental Rights Enforcement Procedure Rules, which the rules were made by the Chief Justice of Nigeria pursuant to the rights, the powers granted him in section 46 sub 3 of the Constitution. Now, paragraph 3 sub B provides that a court, in applying chapter 4, that's the fundamental rights provided for in the Constitution, can make recourse to other international instruments, international treaties and covenants and conventions on human rights. Now, we started by mentioning the Universal Declaration of Human Rights, that's articles 22, 23 and 25 thereof, where the right to work, the right to social security, and the right to a standard of living that makes sure that we have a healthy life of total well-being. This summarily presupposes a guaranteed minimal income. For instance, if I don't have a work, if I'm a young graduate, I just graduated and I can't find a work, must I just fold my hands? Can I only fold my hands and wait for whenever I can get a job? Wouldn't that be an infringement on my right to life? Now, from these sections, from these statutes, from these instruments we've examined, the law is on your side. That there's a right. The Universal Declaration of Human Rights makes it very clear that everyone has a right to social security. These same provisions are supported by several other provisions, myriad other provisions in the International Covenant on Economic, Social and Cultural Rights, the International Covenant on Civil and Political Rights, they all guarantees a citizen's right to have social security, to have a decent standard of living. And the decision of the Enugu State High Court in Ogbe and Attorney General of Enugu State seems to agree with our contention. Now, we have also said that even if the decision of the court is not enough, now paragraph 3A and B of the Fundamental Right Enforcement Procedure Rules also guarantees that the courts, in interpreting our fundamental rights, can make recourse to these international standards.